So you have to, when you hire somebody as a part of the employment agreement, you have to ask them to give up the ownership of the IP he or she develops on the job. And failure to do that could create a ground for the party to say that particular IT, which happens to be a very important component to your service or product, is all of a sudden their own property. Therefore, please pay the license. So in order to avoid these kind of litigation later on, it's very important to spend some time, money, and resource at the very beginning when you hire somebody to make sure that the company IP is protected, even from its own employees. On the job definition is while they are employed on their promise using the company property. These are kind of one guideline. So there's always question as to what happens when they are at home, however, using the company computer or speaking to their colleagues, developing the idea while they're away from the office. These could create some ambiguity, but nonetheless, companies should have a very clear policy where there's no expectation privacy exists when they are on the job using company property such as computers. It's very important for the company to have a policy which employee signs to specify that any intellectual property developed while they're on the job or using the company properties belong to the company. And if there is some ambiguity to it, then they should raise it right away to the company so that the company can negotiate with them.